Today, Stu Flashman, uh, attorney and bill analyst for Livable California, is going to go over the report card that he's created, reporting all legislators against some livable bills that were important to us, where it made sense to use those. But I'll let Stu continue and introduce himself further if he likes, and then start talking about the report card information. Go ahead, Stu.
Okay, thank you. So just to add a little bit to Rick's introduction, I've been serving as one of Livable California's volunteer bill analysts for the last couple of years. So I've been looking through and evaluating the literally thousands of bills that the legislature takes up every session, and making recommendations to the Livable California board as to what we should do with them. In a lot of cases, they're not one of the things that we're interested in, so we ignore them. But we are interested in affordable housing. So bills that have anything to do with affordable housing, or for that matter, with housing in general, we generally will look at and evaluate and decide whether we want to take a position on them. The second issue that we involve ourselves in is local control, because one of the tenets of land use in California is supposed to be local control of land use. It's one of those things that is expected to be an essentially local item and not something that the state steps in and controls. But as we know, the legislature has been over the last few years doing exactly that. And the third item that I deal with, we deal with in reviewing legislative bills, is environmental review, or generally California Environmental Quality Act, CEQA. And essentially the reason for us being concerned about that is, regardless of what type of project it is, and particularly for housing, it's important that whoever is going to take an action, for example, on changing zoning or approving a housing project, understands what the environmental effects of that project are going to be, and if possible, identifies how any harmful effects can be avoided or mitigated, meaning lessened. So we are very concerned about the fact that the legislature over the past few years has been exempting more and more types of projects from CEQA review, and particularly housing projects. Their justification for this is we have this crying need for affordable housing, and we think that's more important than protecting the environment. We respectfully disagree. We think that affordable housing is important, but so is the environment. And the idea of CEQA is not to stop projects, but to have the people who are going to approve that project understand the effects of those projects and decide whether any effects that can't be mitigated or avoided are worth it because of the importance of the project. And the legislature is essentially stepping in and making a blanket determination that if it has to do with housing, then we don't care about the environmental effects. We're going to go ahead and say you don't have to even look at them, never mind think about whether they can be avoided or mitigated. So that's our third area of concern. And there are a lot of bills, and we try and look at all of them. I can't guarantee we've looked at every one that you might think is important, but we've tried to evaluate, identify, and take positions on bills that we think are important. And what this today's about is looking at the bills that we thought were important and how did the legislators vote on them. Not just how did the legislature vote on them, did they pass it or fail or reject it, but how did the individual legislators vote on? Because after all, each of us is represented by two legislators, an assembly person and a senator. And we think it's important that people know how their assembly person and legislator voted on the bills that we think are important. So that's what this report card is all about, is looking at the records, the legislative record on the bills that we think are important, and evaluating how people voted, whether they supported our positions or opposed our positions or ignored the bill entirely. So let me just jump to I'm going to share screen to show you what are the bills that we looked at. Let me find it here. Here we go. Okay, so this is the bills we looked at for the report card, and we narrowed it down because we can't look at everything. And frankly, a lot of bills, there was no sense in trying to do a report card on them because everyone voted one way or the other. And in a lot of cases, nobody voted because a lot of bills get eliminated in one or another committee. And particularly if the bill gets eliminated in a committee in the House of Origin where it started off, then most of the legislators don't ever get to vote on that bill, which may be just as well. But these are the bills that we thought were important enough that we took a position on. And there were some bills that went through the legislature we supported, and there were some bills that went through the legislature that we didn't support, some bills that we hope we had a hand in stopping that were bad bills, and a few bills that we thought were good bills, but nevertheless failed. So I'm going to run through them, and I put them in those four categories of the priority bills for Livable California. First category being good bills that passed the legislature. The second category being bad bills that didn't make it through the legislature, and those are bills that we think we helped keep from being enacted. The third category are bills that we thought were bad bills, but nevertheless they made it through in spite of our best efforts. And the fourth bill, which really there were not too many of these, but there were a few bills that we thought were good bills, but the legislature rejected them. And we are disappointed, but we think that you ought to know how people voted on those bills. So those are the four categories of bills. And I'll just run through them pretty quickly, one by one. In bills that passed, there were a lot of bills that passed that we supported and everybody else supported. And so there's not much sense in putting those on a report card because everyone would get a passing grade on it. Everyone approved it. There are a few that were important enough that I thought they were worth mentioning, even though you can't differentiate in the legislature as to who voted because everybody voted for him. So AB 519 by Schiavo created a work group to devise a consolidated application and coordinated review process for approving financing for affordable housing projects. So this is basically a bill that is hopefully going to make it easier to find financing for affordable housing projects. And one of the biggest problems with affordable housing is cost. There's a lot of affordable housing that could be built if there was enough money. But especially since redevelopment was eliminated, that was a major source of funding for affordable housing. And especially since the federal government has virtually dropped all of its affordable housing support, and the state government has dropped most of its affordable housing support, there's not much money for affordable housing. So this is a bill that would help provide funding. As you can see, it passed with virtually no opposition at all in the Senate, in the Assembly, and one senator that didn't vote on it, but nobody opposed it. So, again, there was no opposition, so you really can't count that as part of our report card because you can't differentiate between one legislator and another. AB 529 by Gabriel likewise had no opposition. This is a bill that would call for revisions to the Uniform Building Code to make it easier for adaptive reuse projects. So adaptive reuse project is you have a building that was built for one purpose and is now going to be changed to another purpose. And the main thing that's going on these days is taking office buildings and converting them to residential use. And that's certainly is a lot less expensive than starting from scratch to build a whole new building, especially if you have to tear down an old building. It's also and frankly, environmentally far better in general, because in terms of, for example, greenhouse gas production, you produce a lot of greenhouse gas when you build a building, regardless of what kind of building it is. If you take a building that already has been built and you reuse it, you're generating far, far less greenhouse gases. So it's better for the environment, and it is frankly a good way of providing housing at a relatively low cost. So we are in favor of, in general, favor of adaptive reuse projects, particularly for converting commercial to residential. So that's why I supported this one. Everybody else did too, and it passed without any problem. The third one, SB 555 by Wahab, is a Stable Affordable Housing Act. This is a plan for development of social housing through acquisition and construction. And social housing is publicly owned housing that has mixed income levels of affordable housing. The idea here is to create a community of different, with a variety of socioeconomic levels within that housing project, and to make it, and that makes it a more stable project, and frankly, we think a better project. That passed, but there was opposition, both in the Senate and the Assembly. So you will see that's one of the bills that we rated senators and Assembly members on, in terms of how they voted on this bill. Did they support it or oppose it? The fourth bill, which is interesting, was SB 17 by Caballero. It's a senior housing tax credit that would have basically allowed a tax credit for developers who were building senior housing. It passed unanimously through both houses, but it was vetoed by the governor based on costs to the state for lost revenue. So again, SB 17, there's no sense in putting in our report card, because everybody would have gotten an A except for the governor, and the governor's not on our report card. So that we didn't include. Second category of bills, bad bills that didn't make it through. So we're looking for a no vote here. And the first bill, SB 239 by Dahl, would have greatly restricted CEQA challenges. It would say the only person who can challenge a CEQA, raise a CEQA challenge to a project is the Attorney General. Now, the Attorney General almost never raises a CEQA challenge. The Attorney General will sometimes join in a CEQA challenge that somebody else raised. But I would say there's no more than 1 or 2 cases a year that the Attorney General jumps on and says, that you approved that under CEQA, that was not right, we're going to challenge it. More often than not, in fact, when the Attorney General says that they're going to challenge CEQA, that they're going to challenge a project on CEQA grounds, the agency that was going to approve it will back off and say, well, let's take another look at that, because we don't want to be fighting the Attorney General on this. At any rate, this bill would have said no private parties or public interest parties can challenge on CEQA. It would have been disastrous. Luckily, it died in its first committee, the Environmental Quality Committee in the Senate. And in fact, what happened was that it was set for hearing. The author did a head count and realized his bill was going to fail miserably, and so he pulled it off the agenda and dropped the hearing. So it never even got heard. So that one, obviously, we can't put on our report card, but it was an important bill, and we had a hand in stopping it. I should say that it was unlikely to get approved, because Dahl is a Republican. Very few Republican bills get approved by the legislature these days, given that there's a supermajority of Democrats in the legislature. SB 393 was an important bill that we felt was a terrible bill, and it did not make it. It was, as it says here, was held in the Assembly Natural Resources Committee. It's become a 2-year bill. We are hoping it will disappear, but there's certainly the potential for the author to modify the bill and resubmit it, reintroduce it, and try and get the legislature to approve it. What it would have done is a couple of things. One, it was, oops, I'm sorry, have a little typo here. Okay. It would require the disclosure of major contributors to CEQA judicial challenges. Sorry. Couple last minute revisions here. That would have been problematic, certainly in some cases. He was aiming at special interest groups that sometimes will bring CEQA challenges and will sometimes fronts have a group that's actually bringing the challenge that isn't funding it. So, for example, it may be that a competing corporation opposes a project and basically pulls together a front group, maybe it call itself Citizens for Great Growth or Citizens for Opposing a Nasty Project. And the funding is all coming from the competing corporation. And he felt that that sort of thing needs to be exposed. The other major group he was aiming it at is labor unions. Labor unions will often oppose a project for labor-specific reasons, but they will sometimes sponsor a judicial challenge under the California Environmental Equality Act. And he felt that was, if you will, flying false colors, that you're calling yourself environmentalist, but what you're really about is labor. And it is true that in some cases, labor unions will file a lawsuit against the project, CEQA lawsuit, and then negotiate a settlement where they get the developer who's involved in the project to agree to what's called approve a project labor agreement, where they agree that they will use union labor to construct the project. Or it may be that they are using non-union contractors, and the labor union will insist you drop that contractor and bring in union contractors because we don't like the people you're using. They're undermining our union. Those, again, Glazer felt that those shouldn't be allowed, but he felt, well, given that he wasn't able to block them, he was saying, well, let's at least expose who's funding it. But of course, a lot of other cases, the funding is coming from very responsible sources. It may be, for example, it's someone who is independently wealthy and believes in the environment and makes a large donation to, let's say, Earth Justice. And Earth Justice provides the funding for a CEQA challenge. They would have to report this contributor as being a major funder of the CEQA challenge. That might deter people from making contributions to environmental organizations because they don't want to be put their name in the spotlight as being responsible for CEQA challenges. So there was a lot of concern, and frankly, there's constitutional questions raised by this in terms of the right of people to be anonymous. For example, when you go out and do a political brochure and you circulate it around your neighborhood opposing something, you don't have to put your name on it. And the Constitution says that's in fact okay. And the Constitution says the government can't force you to put your name on it because that's inhibiting free speech. The other thing it would have done is it would say that a housing project that had survived one round of environmental review would be exempt from any further environmental review. So, for example, you could have a project that was in part of what's called a specific plan, which is a large project, and they have done environmental review of this large area specific plan, and now a large housing project is being built within that specific plan. Well, there's already bills that limit what you have to study on that housing project, but this bill would say you don't have to study it at all, and that could be very damaging, very dangerous. So we oppose that bill. It did not make it out of the Senate. It got a vote of 32-0 to 8. That was not sufficient. No, I'm sorry, take that back. It did make it out of the Senate, 32-0 to 8 abstentions. But then it was held in Assembly Natural Resources Committee. So the Assembly Natural Resources Committee basically says, we're not going to approve this bill. And it's going to be, what it does is it makes it into a 2-year bill, and Glazer can bring it back in January if he feels like it. And I've heard rumors that he is. So that was a bill we opposed, and we were successful. Another bill that we opposed successfully was SB 440 by Skinner, which would have established a new statewide tier of regional agencies to deal with housing finance. And we opposed it basically because it didn't provide any funding for establishing or running the agencies. It would have granted new powers beyond of those of existing finance agencies. And by the way, it was opposed by CalBI, California Building Industry Association, which is a very powerful lobbying group for builders. It was held in the Senate Appropriations Committee and Assembly Appropriations Committee. I don't know whether that's going to come back or not, but we felt it was an unnecessary and just one of these over-enlargement of governmental authority that really didn't need to be there. The fourth bill that we opposed that didn't make it through was SB 689 by Blakespeare. And this was basically going to say that any bicycle transportation plan would be deemed consistent with the local coastal program under the Coastal Act. We felt that this was attempting, and the California Coastal Act, for those who aren't aware, this was passed by initiative, statewide initiative, and it established special regulations to protect the coast. And this was clearly an attempt to, by legislative fiat, override the California Coastal Act. We think that, frankly, was improper. It would be allowing the legislature to override a statewide initiative, voter initiative, and that's something that the Constitution says you can't do. Only the voters can override an initiative, unless the initiative allows that. And the Coastal Act did not provide for that. So that luckily died in its first Senate committee, and consequently, that's not going to show up on our report card because it died in the first committee. There were no votes on it. Now we get to probably one of the more important ones, which is the bills that we thought were bad bills, but still passed. AB 835 by Lee would require the state fire marshal, or will require the state fire marshal, to research and report to the legislature and State Building Standards Commission on establishing standards for allowing single stairway apartment buildings. And it was amended in the Senate to require addressing effects of standards on human health and safety, but it would direct the fire marshal to set standards for approving these types of buildings with only a single stairway, regardless of location. This would overrule the fire marshal's discretion to find such buildings unsafe, especially in high fire hazard severity zones. In other words, right now, the fire marshal has the discretion to say this type of building is not allowed in a high fire zone because it's a high risk. There were amendments in the Senate to address effects of the standards on human health and safety, but the question, it basically, we felt unfairly and improperly ties the hands of the state fire marshal in terms of evaluating and establishing proper standards for fire safety. It passed, however, with almost no opposition. So there's not really much you could say about that bill in terms of who opposed it. Almost nobody opposed it. In fact, nobody opposed it. Only one person didn't vote. The next few bills were more important in terms of they did differentiate. So AB 1449 by Alvarez would be a CEQA exemption for affordable housing projects meeting certain criteria. And we feel that it attempted to limit the projects to those with low risk of impacts, but there's no CEQA review at all. If a project has no risk of impact, then you can do what's called a negative declaration, or you may even be able to find it exempt from CEQA. This basically is doing a blanket exemption. We think that's a bad policy. However, it did make it through both houses and is now going to be law. AB 1633 by Ting. This was in our opinion, a terrible bill. It applies the Housing Accountability Act to CEQA review. What that means is right now there's a Housing Accountability Act, which says if a project has a certain minimum amount of affordable housing in it, and it isn't approved, the developer can sue to challenge the failure to approve the project and make arguments, and it changes the standard of review for what the city has to show in terms of turning down a project. It usually the city has a lot of discretion in deciding to turn down a project. This would say that no, you have to have the majority of the evidence presented has to support turning down the project. It's not, in other words, it's going to become a matter where the judge second guesses the city's decision about rejecting a project. And the judge could say, well, you thought you had enough evidence, but I don't think so. It also allows for the developer to file suit during the administrative process if the developer feels the project is not being approved rapidly enough. So the developer sends a notice to the agency has to finish the environmental review within a very short time period, or else the developer can sue. And what this is going to do is open the door for lots and lots of developer lawsuits. And a lot of city councils will be intimidated by those lawsuits and go ahead and approve projects that really shouldn't have been approved. So we think it's a terrible law, but there it is. And you'll see we've rated who, by the way, in some cases, you'll see the vote was like here 21-3 to 16. These 16 legislators didn't vote. But when you're trying to get a project through the legislature, not voting is the same as voting no. You need a majority of the yes votes. If there's a majority, if there's a majority of those voted yes, but that's not a majority of the House, then the bill fails. So a no vote, not voting counts the same as voting no, and we counted that on our report card. People who didn't vote on the bill, it's as if they voted no. The last bill is SB 423 by Wiener, one of our favorites there. And this bill was probably the most controversial housing bill in the legislature this session. It was opposed by almost all environmental groups. But again, it got approved, but not by much. It was a close vote in some cases. It looks more stronger than it was because Wiener had to run around the floor and buttonhole the various legislators and get them to vote on the bill. A lot of legislators didn't want to vote on it. He pushed them, and some of them were cowed into voting for it. But this bill, most of you probably know about SB 35, which calls for the ministerial approval of residential projects with an affordable component if that municipality's regional housing needs allocation goals had not been reached. And there have been some terrible projects that have been proved, and they basically, what the ministerial means is the city council has no choice. They have to approve the project. And that means essentially that whatever the developer proposes, the city has to approve. It's a terrible bill. It has now been extended in time period, and the SB 35 exempted entirely areas in the coastal zone from its application. This bill narrows that exemption, so there will be SB 35 projects allowed under certain circumstances in the coastal zone, which we think, again, is a terrible idea. It was opposed by almost every environmental group, but nevertheless, the Wiener had enough push to get it through. The last bill is the category of good bills that failed. Most of these bills never got anywhere. The ones we supported that didn't go anywhere. This one got somewhere. This was by Wahab, SB 466. It would have amended the Costa-Hawkins Act, which is an act that was enacted in the 1990s that says if any housing built after the time this bill was enacted is exempt from rent control. What this bill would have done would have said it's not a permanent exemption. You have an exemption. I think it would have limited the exemption to 15 years. It says you get a free ride to charge whatever rent you want for 15 years. After that, if the city feels rent control is warranted, it can institute rent control. We thought that was a reasonable compromise. The legislature disagreed. In the Senate, it failed, but then there was a 15 to 16. It failed 15 to 16. There was a motion to reconsider that passed unanimously, but the author moved it to the inactive file because she could see that it wasn't going to pass. It's possible that the bill can be revived as a 2-year bill, but it's probably unlikely. That the landlord and real estate interests have so much power in the legislature that attempting to do anything to broaden rent control is a very forlorn effort. So that's the bills. Let me just now go to what we found. What were the results of looking at this? So let's start first with the Senate, because they dealt with most of these bills started in the Senate, and so there would be a vote in the Senate. Let's see. Let me pull that bill to the front here. Okay, so here's the Senate report card rather. And let me start. It's in alphabetical order, and you start with the A's and run down here. What we did was we graded the bills that people in the Senate voted on, and a yes vote means they voted for it, but a yes vote, for example, for these bills here, SB 393 onward, a yes vote for these bills was a bad one. We were recommending a no vote. So in this case, this person, Alan, voted for SB 555, one of the bills we supported, so that's good. And he didn't vote on AB 1633 or SB 423, and we thought that was good. So he basically gets good grades on those. He also voted for SB 466, which you remember was the bill to limit to weaken Costa-Hawkins prohibition on rent control. So those bills, the votes on SB 555, AB 1633, and SB 423 were bills that we recommended, as was the vote on SB 466. So there are a total of 7 bills, and he voted for 4 out of the 7. That gave him a percentage of voting in accordance with what Livable California recommended of 57%. That gave him a B. We were very lenient on our grading. Anything above 50% gives you a B. On the other hand, Alvarado Gil.
As a former teacher, I have to say that is really generous.
It is. But you know,
that's a D.
If we had given grades the way most schools give grades, there would be almost no B's. There would be almost no C's. There would be D's, E's, and F's, and that's it. But we tried to be generous that some people, admittedly, some of our positions are not very popular in the legislature. So when someone takes our position, we give them a big thumbs up for that. As you'll see in the Senate, we didn't give a single A. Nobody voted our way, and very few people even got B's. You can see there's about a half dozen B's. There's a fair number of C's, a lot of D's, some E's, and some F's. And F's in the Senate, there was only one person who got an F, and that says he voted wrong on everything, and that was Alvarado Gil. But most of the other people voted with us on at least 1 out of the 7 bills. So that gave you maybe at least an E. So that's the Senate, and this will be put up on the Livable California website, so you can look through and see how your senator voted on these bills and evaluate whether you want to continue to support them and vote for them the next time they're up on the ballot. Let's move on to the Assembly. So the Assembly, it takes up more space. There are more of them. So it took 2 whole pages. But again, some of these bills never got to the Assembly. So none of the Assembly people had to take a position. SB 393 got stalled in the Senate. SB 466 got defeated in the Senate. And SB 440 made it into the Assembly, but got held in committee. And so that one, only those members of the Assembly who were on the committee that held the bill got to vote on it. And so they basically were only 4 bills that everyone in the Assembly voted on that we graded. There still, however, were only 2 people who got A's. That was Otis, and you'll notice that Otis got an A, but that was in part because of not voting on some of the bad bills. Again, that counts the same as voting no, but on the other hand, Muratsuchi voted no on all 3 of the bad bills that we recommended a no vote and voted yes. So Muratsuchi, really, we gave him an A+. It's the only legislator who really was emphatically on our side on every single one of our bills. So we give him a attaboy. But there were a fair number of people who voted against us on every bill. Flora, Gallagher, Hoover, Lee, Joe Patterson, Valencia, all of those, they didn't agree with us on a single one of our bills. So it was a disappointing showing overall in the Assembly. I think actually overall it was worse in the Assembly than it was in the Senate, although I haven't actually calculated out what the average score was for senators versus Assembly members. But neither was very good. But at least we got a few A's. We got 2 A's in the Assembly. We only got 1 A in the Senate. So that's the scorecard and a report card for this last session. It's not very encouraging. We did better than we have in the past. We were more active in our lobbying than we had in the past. We hope to be even more active next session. And if any of you are interested in helping out with the evaluating these bills, please get in touch with Rick and we can add you to our legislative analyst committee. So that's that part of what I was going to talk about. The other thing I want to spend a few minutes on is we have filed an amicus brief in a lawsuit that has been filed challenging SB 10. And those of you may remember that SB 10 was approved a couple of years ago, and it allows municipalities to enact a new zoning, which would be 10 units per parcel. And they can do it without any CEQA review. The only CEQA review would be for projects approved under that zoning. But the zoning itself, they exempted from CEQA. And this was the more important and more disturbing part, they allow the new zoning to be enacted regardless of anything that would prohibit that zoning, including citizen initiatives. And as you probably know, there have been lots of cities and counties that have adopted initiatives to limit growth, in particular to declare areas to be open space and try and protect open space. That's often done by what's called an urban limit line. And those have been enacted by voters in a number of cities and counties. as well as some that have been enacted by the Board of Supervisors or City Council. This would allow those to be overridden. We thought that was horrible, and a number of other groups also opposed it, and in particular, a group called the AIDS Healthcare Foundation in Los Angeles filed a lawsuit, and they were joined by one of the cities, I believe it was a city in Los Angeles County, that also joined in that lawsuit. They lost in the trial court. They took it up on appeal, and Livable California and a citizens group in Martinez called 1,000 Friends of Martinez both agreed to submit an amicus brief in support of the appeal. And I'm going to just spend a couple of minutes talking about that amicus brief. Let me bring up the, here we are. So SB 10 was an interesting bill. Let's see, hold on, did I? Yeah, so SB 10 was an interesting bill. When it was first introduced, it had legislative findings. The legislative findings said that the legislature finds and declare that ensuring the adequate production of affordable housing is a matter of statewide concern. Well, it is, and we agree with that. But the problem is that SB 10 doesn't guarantee any affordable housing. It does do an upzoning to 10 units per parcel, but it doesn't require that any of those units on any parcels anywhere be affordable. Furthermore, it doesn't even require that if you're going to use SB 10 to override an initiative, it doesn't require that you have a need for affordable housing in that city. A city can use SB 10 to override a citizen's initiative to protect open space and use that override to build entirely market rate projects. We thought that was horrible. But what's interesting here is when the bill got into the assembly, Wiener changed the findings. As you'll see, it had said it to adequate production of affordable housing. What he changed it to is to say the ledger finds and declares that provision of adequate housing in light of the severe shortage of housing at all income levels in this state is a matter of statewide concern and not a municipal affair. That is what allows him to override the Section 5, Article 11 of the California Constitution and require all cities, including charter cities, to follow this law. The issue is, what evidence did the legislature have that there is a severe shortage of housing in all income levels? And normally, you may be aware, probably aren't aware, but the courts give tremendous deference to legislative findings. If the legislature says something is true, the courts will ordinarily say, well, if the legislature says it's true, it's true. But in the case when you're dealing with a constitutional right, and initiative is a constitutional right, the right of initiative is a right of citizens. When you're dealing with a constitutional right, the courts have said, no, there you have to look at the legislative findings carefully and see if they're really supported. So let's see what happened here. Let's go back and look at what the state's own figures show about affordable housing and about housing in general. So this is a statewide analysis done by the Department of Housing and Housing and Community Development, the people who are responsible at the state level for housing. HCD compiled all of the numbers statewide on how people had done on their RHNA goals. And as you can see, cities did really very poorly on very low income and on low income, and they did somewhat better, but not great on moderate income. But look at above moderate income. 144% of the RHNA goals statewide. And this was as of April of this year, with almost a full year left to reach the RHNA goal. They've already gone way past it. And when you look at individual areas of the city, some of them are just outrageously. In one of the urban areas in the state, the above moderate income was 300% of the RENA goal. So we filed our amicus brief and we pointed all this out, and we said, you can't justify this bill based on the findings. The findings simply are not supported by the evidence. The evidence says that there is no shortage of housing at the above moderate income level, and therefore the legislature's reliance on there being a shortage at all income levels was misplaced, and the bill should be found unconstitutional. So that's where we're at. We filed the lawsuit. We filed the amicus brief. It was an issue that had not been brought up in the trial court, and we were pretty nervous about whether the Court of Appeal would even accept the amicus brief. But we pointed out that there are provisions that allow new issues to be raised if they are of public interest and there's no dispute about the facts involved. And we said this falls under both of those. Certainly, whether you're overriding initiatives, that's a matter of great public concern. And we're using the state's own figures, so how can there be any dispute about them? So lo and behold, the Court of Appeal accepted the amicus brief, and they accepted our motion for judicial notice, which asked the court to take notice of all of the RENA numbers and a number of other documents that were essentially established facts. So at this point, they've accepted the brief, they've accepted the judicial notice, and they have asked all of the other parties, namely the state, to provide a response within 21 days. And we're hopeful that when it gets to the point of hearing this appeal, the justices will be skeptical of whether this legislation was proper in terms of having the findings that were supported by evidence. We'll just have to see. The case has now been fully briefed, with the exception of the 21 days for the state to respond to the amicus brief. But after that, it will be up for hearing, and we'll just have to wait and see. But I should say that usually with these sort of appellate hearings, it is possible for the public to attend via internet link and as it were, sit in on the hearing and hear what's said. So you might want to put that on your calendar when it gets set for hearing. We'll try and keep you informed about what happens. So that's all I have today, and I'm sorry for taking so long.